Hey everyone, and welcome back to Law Unwrapped. Today, we're re-tackling a topic that causes a lot of stress and heartbreak for millions of people every year: U.S. visa denials. You've spent months, maybe even years, planning your trip, gathering documents, and preparing for that interview, only to walk out with a denial slip. It feels devastating, like a door has been slammed shut. But I am here to tell you that a visa denial is not necessarily the end of your journey. In fact, it can be the starting point for a successful reapplication, if you understand why you were denied and what steps to take next. First, let's get one thing straight. A U.S. visa interview is not a casual chat. It's a legal proceeding where a consular officer, in a matter of minutes, makes a legally binding decision about your eligibility to enter the United States. They aren't just checking your paperwork. They are assessing your credibility, your intentions, and your overall situation based on U.S. immigration law. Millions apply each year, and a significant number face denials. So, if this has happened to you, no, you are far from alone. The key is to see this denial not as a failure, but as critical feedback. So, why was your visa denied? Let's break down the most common reasons, which are usually cited by a section of the Immigration and Nationality Act. The most frequent reason for non-immigrant visa denials, like for tourism or study, is Section 214B. This sounds technical, but it boils down to one simple concept. You failed to convince the consular officer that you have strong ties to your home country and intend to return after your temporary stay in the U.S. Under U.S. law, every visa applicant is presumed to be an intending immigrant until they prove otherwise. Strong ties can include a stable job, property ownership, family responsibilities, or deep community involvement. If the officer suspects you might overstay your visa or try to find work illegally, they will deny you under 214B. It's not about them disliking you. It's about you not meeting a specific legal burden of proof. Let's say you're a recent graduate with no job and no property, applying for a tourist visa. The officer might logically conclude that you have very little pulling you back to your home country. Your application is weak from their perspective. The burden is on you to demonstrate that you have every reason to come back. We'll talk about how to strengthen this later. Next up is Section 221G. This one is a bit different. A 221G refusal is technically a temporary denial. It means the consular officer needs more information or has to conduct additional background checks before making a final decision. This is often called administrative processing. It can happen for a variety of reasons. Maybe you were missing a specific document, like a financial statement or a letter of invitation. Or maybe something in your application or interview triggered a need for a more in-depth security or background check. A 221G will come with instructions on what you need to do next, whether it's submitting more documents or simply waiting. While the wait can be frustrating and long, it's not a final no. It's a not yet. Then we have the more serious category, Section 212A. This section covers various grounds of inadmissibility. This means there is something specific in your past that makes you legally ineligible to enter the United States, at least without a special waiver. These grounds are extensive and can include past immigration violations, like overstaying a previous visa, a criminal record, certain health-related issues, or misrepresentation, which means lying or providing fraudulent documents during any part of the visa process. A denial under 212A is a significant hurdle. For example, if you were caught working illegally on a previous tourist visa, you would likely be found inadmissible. Simply reapplying won't work. You'll need to address the underlying issue, which often requires legal assistance and a waiver application. Finally, there are simple technical errors. You'd be surprised how often this happens. You might have filled out the DS-160 form incorrectly, uploaded a photo that doesn't meet the specifications, or simply brought the wrong supporting documents to the interview. The officer doesn't have time to help you fix these mistakes on the spot, so a denial is often the result. This is the easiest type of denial to fix, but it highlights the absolute importance of double-checking and even triple-checking every single detail before you submit and before you show up for your interview. So, you've been denied. What's your next move? The first step is crucial. Don't panic, and do not rush to reapply immediately. This is the biggest mistake people make. Reapplying a week later with the exact same information and circumstances is a waste of time and money. It signals to the consular officers that you haven't understood or addressed the reason for your denial. Your first action is to carefully review the refusal sheet the officer gave you. It will state the section of the law under which you were denied 214B, 221G, or 212A. This is your roadmap. If you were denied under 214B for weak ties, you need to honestly assess your situation. Has it changed since your application? If not, you need to wait until it does. A substantial change is key. This could mean getting a new, stable, well-paying job. It could mean enrolling in a university program in your home country. It could be purchasing property or getting married. When you reapply, you must be able to demonstrate a significant positive change in your circumstances. Simply getting a letter from your uncle saying you'll return isn't enough. You need tangible, verifiable proof of your strong ties. Prepare a clear, concise explanation of your purpose of travel and your solid plans to return. Remember, consistency between your documents, your application form, and your interview answers is paramount. If your denial was a 221G, follow the instructions precisely. If they asked for additional documents, provide them exactly as requested. If you are placed in administrative processing, unfortunately, the main thing you can do is wait. You can check your case status online through the CEAC website, but repeatedly contacting the embassy or consulate won't speed up the process. It's a test of patience. Now, if you were denied under 212A for inadmissibility, your path is more complex. You can't just fix this by showing a new job. You need to address the root cause. This often involves applying for a waiver of inadmissibility, such as an I-601 or I-212 waiver. These applications are complicated and require you to prove, for example, that your U.S. citizen or permanent resident family member would suffer extreme hardship if you are not allowed to enter the U.S. For these cases, I strongly recommend seeking experienced legal help. Navigating waivers is not a do-it-yourself project for most people. An attorney can assess your eligibility for a waiver and help you prepare a strong, persuasive case. Let me share a quick example. We knew a student who applied for a tourist visa to visit Disney World. He was in his early 20s, unemployed, and living with his parents. He was denied under 214B. It made sense. He had very few ties. He was disappointed, but instead of just reapplying, he took a year to make changes. He got a full-time job at a reputable company, enrolled in a part-time professional certification course to advance his career, and started saving money in his own bank account. When he reapplied a year later, he brought his employment contract, pay stubs, bank statements, and proof of his course enrollment. He was able to confidently explain his stable life at home and his plans for the future. His visa was approved because his circumstances had materially changed for the better. The key takeaway here is this: a visa denial is not a personal judgment, it's a legal one. The officer is not your friend. They are an adjudicator. Your job is to present a case that is clear, consistent, and convincing. Prepare meticulously, know your story inside and out. Be ready to answer questions about your job, your family, your finances, and your travel plans honestly and directly. Don't memorize a script, but be prepared. If you're applying for a non-immigrant visa, every answer should reinforce your primary intention, to visit the U.S. for a temporary, legitimate purpose and then return home. If you've been denied multiple times, or if your case involves inadmissibility, don't keep trying the same thing and expecting a different result. That's the time to invest in professional legal advice. An immigration lawyer can review your entire history, identify the core problem, and devise a strategy that gives you the best possible chance of success. Remember, the law is not just a set of restrictive rules. It's a roadmap if you know how to use it. Understanding the reasons for denial empowers you to navigate the system effectively. Learn from the feedback, prepare diligently, and when the time is right, you can try again with a much stronger case and renewed confidence. Thank you so much for watching. I hope this has clarified the visa denial process for you. If you found this helpful, please hit that like button, subscribe to our channel, and ring the bell so you don't miss our future videos. Have a question or a story to share? Drop it in the comments below. This is Law Unwrapped, simplifying the law, empowering your future. See you in the next video.